This is Dart Container of Michigan LLC et al. Versus Stephen Mills et al. Docket number 20-333CB. This is the time set for hearing on the plaintiff's amended motion to compel discovery as to defendant Hughes. And I'll take appearances of counsel first, please.
Good afternoon, Your Honor. Brandon Shoemaker appearing on behalf of the Dart plaintiffs.
Good afternoon, Jim Jensen from Foster Swift on behalf of the plaintiffs.
Good afternoon, Your Honor. Jennifer Gross appearing on behalf of defendant Hughes. I also have with me in my office my law clerk, Katerina Vikovic, just so you know she's also present.
All right, thank you. Go ahead, Mr. Shoemaker.
Thank you, Your Honor. And I know how much time the court spends and takes these motions seriously, so I'll try to be non-repetitive of any arguments made in the brief, but we'll highlight some happenings that have occurred since it was filed and what is remaining in dispute. So I'll start with the first deficiency identified by the motion, which is the issues raised in our initial discovery motion that were changed to the amended motion before the court. The issues dealt with prior discovery responses of Hughes to Dart's discovery requests, and in particular dealt with the absence of a notarized signature page, and as part of the responses, Hughes, to his credit, disclosed a new transaction dealing with J.R. Hughes. However, he didn't provide the identification of the transaction, how much was paid, or whether any payments were made to Mills. And just for the ease of the court, unless the court needs me to go through the discovery requests, I've identified them in the brief on what we believe they were responsive to. Since the motion was filed, Hughes has provided a notarized signature page for the responses and has provided a 1099 showing how much has been paid and who issued the 1099, so presumably who made the payment. So really the only issues remaining on the first deficiency is the identification of the transaction involved and if any payment was issued from the transaction to Mills or MREC. The second issue is the duty to supplement issue that was raised in the motion. As we spelled out in the motion on two separate occasions, Dart learned at depositions of witnesses that Hughes had documents in their possession that were responsive to prior discovery requests and at minimum should have been disclosed in supplemental initial disclosures. The first incident dealt with a series of emails relating to the Walden of the Park transaction that were discovered at Stans Gilhule's deposition. And as we pointed out for the court, in a prior notice of taking deposition, there were requests asking Hughes to produce any communications with any person or entity regarding the project known as Walden of the Park. So that was the first request for which it was responsive. In light of that discovery, we did send a May 12th letter to Hughes requesting that they supplement disclosures. We were not privy to the email. I understand in the response there was an indication that there was an email server issue. We were not privy to that. But prior to receiving any response, a second incident occurred where we learned of a letter from Newmark to Hughes that was marked as an exhibit that at minimum related to Walden on the Park and dealt with what Newmark's view is the impropriety of Hughes's conduct. Now, when it came to Mr. Hughes's deposition, he previously testified that he didn't know why Newmark had terminated him. This letter gave us a reason. So at minimum, it needed to supplement the testimony in a seasonable fashion. And more to the heart of the matter is that the evidence newly discovered at that deposition addressed one of the issues the court highlighted in its hearing on the motion for partial summary disposition, which, as the court is aware, we filed a motion for reconsideration, and I'm not getting into the merits of that. But at minimum, Hughes can disagree with the position that Newmark takes in the letter, but is relevant to the case. And after learning of it, we filed a motion for reconsideration. A substantial portion of it was based on that letter. The bottom line is, Your Honor, it should have been disclosed. And what's concerning from Dart's perspective is that there's a very real risk, given these two prior incidents, that we'll continue to learn of documents that have not been produced, whether through inadvertence or otherwise, that should have been disclosed, and that we'll be learning for them for the first time at trial or subsequent motion practice. I understand the response to our motion indicates that, or takes the position that we didn't try to resolve it. First, respectfully, Your Honor, we don't know anything about server issues in response to the May 12th letter. And more than anything, it's a red herring. Subsection E of 2.302 of the court rules requires supplementation regardless of any request for it. I mean, even if our attempt to resolve the issues was relevant to it, we did take reasonable steps to resolve it. Not only did we send the May 12th letter, but before filing the motion, we sent email correspondence requesting an opportunity to work it out. We sent the motion prior to filing. We extended the time period to respond. And even the day of the filing, I reached out and gave an opportunity to address the issues. Even as late as yesterday, I gave an opportunity in an email to talk and see if we could work anything out. Nothing happened because of that. So quite frankly, Your Honor, an order shouldn't be necessary, but in DART's view, we have no choice but to request an order to supplement all responses to prior discovery in order to ensure that we have all existing documents.
Can I just interject here and ask you, but
Yeah.
obviously you have the letter now from Newmark to Hughes's counsel, correct?
Correct.
And then do you have the Walton on the Park emails?
We do now, yes.
You do now?
Yes.
Okay, all right, I understand.
After the deposition, Your Honor, yes, we got them as part of.
Yes, I understand. Go ahead.
And the last issue, Your Honor, deals with the latest round of discovery. And I'm going to start by apologizing for the court. And it looks as though inadvertently part of Exhibit 9, which were the recent discovery requests, was left out, which is the request for admission that was sent from DART to Hughes. And I'll read it, Your Honor. Quote, please admit that John Robert Hughes and or J.R. Hughes Management Company never made payment of a finder's fee to an employee or consultant of a client without informing and obtaining the approval of the client, except for your payments to Mills Real Estate Consulting LLC and or Stephen A. Mills that are the subject of this case, end quote. The ultimate answer was a denial, along with some objections. And anticipating a possible denial, the interrogatories then were very targeted and requested that if that was in fact denied, that Hughes set forth in detail all such finder's fees, the name of the person who received them, the amount of the payment, the date of the payment, and the information of the person whom the person was employed by, among others. So in DART's position, this is a very targeted request that is clear on what the information is being sought. And the second interrogatory dealt with payments Mr. Hughes had received from Newmark while he was operating under the Newmark brokerage. And the reason we're asking for those in particular, Your Honor, is throughout the case, Hughes has taken the position that the net commissions column that's identified in the exhibit to the discovery requests was not the full amount he's received. So if that's the case, we are simply asking for information related to what was the amount he received. And relating to the first interrogatory, the information sought there is relevant because, quite frankly, in DART's view, it contradicts prior deposition testimony, which is Mr. Hughes testified that he didn't recall ever making similar payments to other employees. Now, if he didn't recall and then discovered something after the fact, that's explainable, but we need the information to verify it. So in this case, Your Honor, I would say that DART disagrees with the objections and would like the information requested in the discovery request. And unless the court has any questions of me at this time, I'd request the relief requested in the motion.
I don't have any, but I may when we return to you for rebuttal. So I'll go to Ms. Gross.
Thank you, Your Honor. I'm going to break down my responses, kind of organize in the same way that Mr. Schumacher has. So with regard to the first issue of the prior discovery, the objection seems to be, or the objection to our response is that they want to know whether or not this newly identified transaction for which we affirmatively gave information and provided 1099, even though that 1099 had been produced in extensive financial records, which had been produced back in November of 2020 in response to plaintiff's requests. It had already been produced, was in plaintiff's possession, but we identified the document in order to assist counsel in locating it. However, My client has already made representations in response to discovery requests and also in his deposition that he's provided records of all payments that he has made to Mr. Mills. He provided a list early on in this process before litigation was commenced. He was asked questions about that list, and counsel had an opportunity to, during his position, and did so, extensively asking questions about that list of payments. He's testified that those are all the payments that he has made to Mr. Mills. And he's indicated that he cannot, he does not have information more particular than what he's already provided to tie those payments together. So frankly, Your Honor, there just isn't the information that counsel is seeking, and we've made that very clear on numerous occasions. We're not trying to hide any information. We don't have what we don't have. And Mr. Mills is the recipient of the payments. Perhaps he may be able to shed more light on what the reasons for those payments were or what deals they were tied to. My client has testified that he doesn't have the ability to tie, doesn't have the recollection or the information to tie those together. We provided records of all payments. We provided a full check register for his company, that J.R. Hughes Management Company, from which any and all payments were made, and my client has testified to that as well. We provide the full check register. It's got a list of all the payments made out of the company. Mr. Mills's name is identified in every instance of a payment to Mr. Mills from Mr. Hughes. So as far as we're concerned, we have given absolutely all the information that is available with regard in response to that question. And we fully responded. And so at this point, there is no need for an order for further response, nor is it warranted, because we fully comply with our obligation. With regards to the motion to the supplemental issue, I would contest Mr. Schumacher's statement that we have not provided the emails with regard to Walton on the Park. We produced about 292 pages of documents with regard to Walton on the Park, which are Hughes 00, or the Bates number is Hughes 000001 through 292. Those were produced, I believe, on November 10th of 2020. And while I don't specific email that Mr. Schumacher is referring to, I believe it came up during Mr. Gilhool's deposition. And Mr. Gilhool is a DART employee. He was at the relevant time, and he currently still is. Those emails were with him. So really they are already in DART's possession and control anyway. And DART has not yet produced any emails to us, even though we made requests. We're still trying to get them to agree to produce emails that they are responsive to our request from months ago. But that aside, did produce those emails. I don't think that there's anything that with regard to Mr. Gilhool's emails in that deposition that we didn't provide. So I would say that that's not true, not a true statement that we didn't provide those. With regard to the letter, it's true that was not provided until the deposition of Newmark, and in our view, it was not necessarily responsive, but we didn't even have the opportunity to answer the question, because as soon as that was provided, plaintiffs filed their motion. They didn't give us the opportunity to even discuss it or even fully understand why they were filing a motion. We certainly would have answered, a discovery request related to that or supplemented. In fact, as I indicated in my response, we've already done the process of supplementing, and that was predating any communication from opposing counsel, which, as I indicated, through issues with my firm, I did not receive. It was not copied to my assistant, and it went into my junk email, but that's still on me. I realize that, but the point is, we were not trying to be evasive. We were trying to fulfill our obligation. When it came to my attention that perhaps my client's searches were insufficient, I have taken copies of his inbox files and any other business records he may have in his possession, and we are in the process of searching through, using a software program that we pay for to search through and provide responsive documents. So we feel that we are, especially considering the fact that DART has produced nothing in terms of communications at this point, we feel that we are definitely attempting in good faith to comply with our obligations under the court rules. And that's with regard to the supplementation issue. So I would respectfully I would respectfully ask that the court not issue an order. I don't think it's necessary or warranted under the circumstances. And finally, with regard to the third issue, the way that, as indicated in my objections and in my response to this court, the wording of the request to admit, as stated, does not allow any other relief or any other opportunity to respond truthfully is except to deny the statement, because Mr. Hughes, as he testified to, does not specifically recall whether or not those types of payments were made to any other individual or entity. But he would not agree that it's absolutely not true that those payments were made. So the way that the request to admit is worded, had it been, the wording been better defined or less vague, we could have maybe provided a more clearer answer to it. But as it's stated, it isn't, it's pretty broad, and it's asking a pretty broad question. And it doesn't include any definitions of important terms like finder's fee or consultant or permission. Does that mean that, if my client paid anyone, he would have to, if he didn't specifically get a written contract authorizing him to pay them, is that included in that request? It's hard for us to tell. And rather than try to narrow down what that means, counsel filed a motion in this case. And while he did give me the opportunity to discuss it, it was a day before the motion was filed. And it was on a day when I had another deposition and I had other matters that I couldn't immediately respond to this issue.
I understand that. I saw that tight time frame. I get it. But I was just told that you two had an opportunity to consult yesterday. So did you try to hash out, like, what are you looking for? What exactly are you going by as far as a definition of finder's fee or consulting?
No, but Your Honor, at that point, I had already outlined those questions in the motion response, and also in my objections. So I think that they were clearly before counsel. I did not reach out. I did not have the opportunity to reach out yesterday to try to resolve it, because my view is that counsel is going to not going to, based on their aggressive position, I feel that they were not going to be satisfied unless we stipulate to an order for production. I don't think that that's warranted here, because I feel that we have been complying with our discovery obligations. An order isn't necessary. All of these issues that are in the motion currently, with regard, except for the third issue, are effectively resolved already. So there's no need for an order, but I feel that based on counsel's previous statements to me, that they want us to stipulate to something I didn't feel comfortable stipulating to, and I don't think it's warranted. So I didn't feel that, given their aggressive posture and their rush to file a motion, that there was really any resolution to be had prior to the hearing today. But I would like, with regard to the payment issue, as currently written, with regard to interrogatory number 3 or number 2 sample, our prior discovery requests have already fully answered that. Mr. Schumacher is asking whether or not, saying that we never gave responses about how much he was paid by Newmark. Absolutely, we did. We responded under oath that said that Mr. Hughes received approximately 65% of the net commission, but if he went over a certain percentage every year, he got paid an additional percentage. That testimony was verified by the deposition by plaintiffs of Mr. Leesfeld, who was a representative of Newmark. They stated the exact same thing in their response, and they couldn't tie it any closer to particular deals, because he received one 1099 a year. He wasn't 1099 by the deal. So we have provided everything in our possession and control that would tell the amount of information that he received, and they're just not liking the answer. So they're asking for an order for us to provide something that doesn't exist, and which we've fully complied with already. So respectfully, Your Honor, I just don't see that there's anything that we could stipulate to with regard to that, because we've already fully responded to that exact interrogatory, or not exact, but very similarly worded interrogatory in our most recent supplemental responses.
All right, thank you. Mr. Shoemaker? Oh, you're on mute.
You're muted.
Can you hear me?
Yes, I should have brought my coffee mug that someone gave me so I could sip from it, and it's printed on it. You're on mute.
That's the phrase of the year, isn't it?
Yes, it is.
So this will be very, very brief. With regards to the list of the payments with the first issue, if the answer is, I can't trace it, I can't change what the answer is, but we need the answer. Just like with all of the other discovery requests, if there is no way to trace it and just simply 65 to 70% is it, that's the answer. The point is we will have an answer that we can hold Hughes to. And the other, I typically don't go into this, back and forth of, well, they're doing this, they're doing that, but I do need to correct one thing that keeps coming up, and to whatever extent it's going to play on this court's decision, is that Hughes has taken the position that DART is obstructing discovery. What counsel is referring to is the email agreement that was put together in response to the initial motion we filed back probably 3 weeks ago now. And in that response, we had agreed to a solution to deal with the correspondence issue, given how broad the request was. The agreement was that within 14 days of the agreement, we would receive a list of search terms. That was towards the end of March, if I'm remembering it correctly. We just received the search terms on May 25th, so that was last Tuesday. So prior to that, we had no search terms to do. We've narrowed it down to non-objectionable search terms and are trying to figure out how responsive it is. So we're, given the amount of time that we've had, a week, we're taking reasonable efforts to do so. We aren't trying to obstruct discovery, and we've tried our best, A, not to dock dump, and B, to keep things as timely as possible. So with that, I have no further rebuttal, Your Honor.
Okay, thank you. So there's now a notarized signature. We know that is true. We can cross that off the list. As far as the quote, previously unknown real estate transaction, end quote, the defendant Hughes has provided a 1099, but obviously the 1099 doesn't identify the transaction or whether Hughes paid mills out of the commission. Defendant Hughes says, well, he can't recall, can't trace it, can't link the payments, but I agree with the plaintiff's point, and that is, if that is the case, then answer it as such so that there's a record of that and you're held to it. With respect to the previous answers, well, the previous discovery that the emails on pertaining to Walton on the Park and the letter from Newmark to Hughes, there does seem to be at least maybe a tacit admission by the defendants that their searching for these communications hasn't been all that perfect or great, because they're now doing it by means of a discovery production software assistance. So I think that the letter from Newmark to Hughes, I mean, he didn't know at his deposition, but at his deposition, the letter hadn't been written yet. But nevertheless, I think, with the emails that came up after discovery was answered, and now all of a sudden there's emails and they were in defendant Hughes' possession, he had to know about them if he was going to be using them. That's at least an indication that not everything had been produced. So I think that the plaintiff is warranted in asking for an order that would supplement those discovery requests. And then finally, with respect to the third category, which is the 421 interrogatories and requests for production, I looked at the answers, and it seemed to me that there were two things. And one is that the defendant Hughes was saying payments made to others aren't relevant. I think they are relevant. Plaintiff addressed this in their motion, their amended motion. Mr. Hughes testified he hadn't made similar payments to employees of other clients. Then he said he did make similar payments. And there's an indication at least that he's using or may use such payments as a defense to the plaintiff's claims. I think it truly matters if the payments that are the subject of this case were unique to the parties in this case, or were they made as a matter of course, in other matters as well. So it is relevant. And I would grant the plaintiff's request to compel with respect to that as well. Now, it's hard for me to rule on the second part of what's at issue here, which is the vagueness, the alleged vagueness of finder's fee and consulting. I guess I can only say if the two councils need to talk about that in order to pinpoint what it is that you're looking for. I mean, I can figure it out, but I don't matter. I understand it's the type of payments that are at issue in this case, but I think you maybe need to have a discussion about that. And I would, again, I would grant the plaintiff's motion to compel in that regard as well. So really all three categories, the plaintiff is getting some relief in, and I would order that to be produced. And again, if the answer is I don't know, then the answer is I don't know. If the answer is I can't recall, then the answer is I can't recall. But I would order that to be complied with in 14 days from the date of the court's order. And I would also suggest, I see both your points and your criticism of the other side. However, let me just say, you're probably both a little to blame here. I do think that plaintiff has been a bit aggressive. Here's our motion, let us know tomorrow or we'll file it, is not very considerate of another attorney's timeframes. And on the other hand, turning around and calling names back to the other side as a result is not very productive either. So I'm going to hold you both accountable on that and ask you to please, I know that in this world, emails are really efficient many, many times. You can get a lot done, lawyers especially, judges too, via email. But sometimes an actual conversation is irreplaceable. So, I would strongly urge the two of you to pick up a telephone and speak to each other where you can have a real back and forth conversation in order to work things out before a motion is filed, and to refrain from calling names, and especially ones that would disparage opposing counsel to the judge, even if I know that it sometimes isn't true. It's disparaging. And so I think if you can go forward with that, I will, again, as I said, grant the order to grant an order to compel, but I'm not awarding costs.
Understood. Thank you, Your Honor.
Thank you. If there's
Your Honor.
nothing further, that'll conclude our hearing.
Nothing further